Back to today's question then. Does a will avoid probate? Well, let's start before we get to answering the question so that we're all on the same page about what a will actually is. Well, as you probably know, it is a legal document. And in that legal document, you are going to do a number of things. One, you're going to talk about what you own and who it is going to go to at the time of your death. So you might talk about your house, your car, your bank accounts, your investments, whatever it happens to be, and who it is you want to receive those assets at the time of your death. Now, the will might be even more general than that sometimes. It might simply say everything that I own goes to my spouse without particularly listing out the individual assets, or maybe everything that I own goes to my children. So what you own, who it goes to, and who it is that's going to be in charge of making sure that happens. That person under Michigan law is what we call a personal representative. That's the person that you're giving the task of settling your estate to. And if you have minor children, in your will, you will talk about who's going to raise your minor children. That would be the guardian. And you will talk about who will manage the minor child's estate, otherwise known as a conservator. So a lot of who's and some what's involved in this legal document that we call a will. What do you have to do in order to have a valid will in Michigan? Well, you do have to be an adult. That means you have to be 18 years old. You have to have what the law calls capacity, or meaning that you are of sound mind. Essentially, that means that you know what you own, you know who your loved ones are, and you know where you want your estate to go at the time of your death. A will in Michigan also still has to be in writing. It's going to have to be signed by you and signed by 2 witnesses. There's another will in Michigan that's called a holographic will, and that will is going to be dated and signed by you at the end of the document, but basically the material portions of the will are in your handwriting. So the normal will is going to be a typed document, whereas a holographic will is something that you might just write out on your own and date it and sign it. But as long as it qualifies under the statute, it will be a valid will in the state of Michigan. So let's ask ourselves this question. So we know what a will is. We know what it takes to have a will. When does your will become effective? And when we look at when your will becomes effective, we will answer the question, does a will avoid probate? Here's what I tell people during seminars. I tell people during seminars that a will is a meaningless document until 3 things have happened. And until all 3 of these things have happened, that will is meaningless. What are the 3 things? 1, you die. What does that mean? That means a will is of no binding effect at all until you die. No matter what you say in your will, as long as you're still alive, you can do with your estate whatever you want to do with your estate. You can sell it, you can give it away, you can do whatever it is that you want to do with it. Second, the will only becomes effective when a probate estate is opened, which obviously doesn't occur until after your death. And the third requirement is that the will only becomes effective once it is accepted by the probate court as part of your probate estate. So let's look at those again. It is a meaningless document until 3 things happen. 1, you die. 2, a probate estate is opened. And 3, the will is accepted by the probate court. So if you look at those requirements for the will to be effective, we have essentially answered that question, Does a will avoid probate? No. The will doesn't avoid probate at all. In fact, the will only becomes effective once a probate estate is open. One of the most common mistakes that people make is thinking that having a will somehow avoids probate. I can't tell you, and Amanda can't tell you, how many times somebody comes in the office, they talk, they want to have a will. When we ask them, why do you want to have a will? Their answer almost always is, I want to have a will because I want to avoid probate. They have a goal. They have a goal of avoiding probate. They've made a decision that they don't want their estate to go through a probate, and they want a will to make that happen. Well, that is one of the most common mistakes that people make because wills do not avoid probate. Having a will is not going to avoid your estate from going through probate. And we might ask ourselves, why is that? This common misunderstanding about the way wills work. And I think of it in this terms. Take a husband and wife. Husband and wife, maybe they both have wills. Maybe they jointly own all of their assets, which is pretty common. And then one of them dies. And in the end, all of the estate goes to the surviving spouse, and it never had to go through probate. Well, it didn't avoid probate because of the will, though. It avoided probate because the assets were jointly owned with the spouse. Essentially, the will was never needed. In that case, the will only would have been needed if the first spouse who had died owned something in just his or her name, something where the other spouse was not a joint owner or a beneficiary on, and then that asset would now have to go through probate. So essentially, all the will really does is names the person that you want to be in charge of probating the estate, and it directs that person where to send your estate when probate is finished. So if you're thinking about having a will to avoid probate, understand, please, that a will doesn't avoid probate. That doesn't mean wills are not important, but understand it is not a probate avoidance tool. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.